All right, welcome everybody. Oh, wow, everything got really quiet. That's fantastic. Well, thank you all for coming here to the National Press Club. My name is Derek Wallbank. I am a member of the board of the National Press Club. I also run the breaking news desk for government for Bloomberg News here in Washington. Nothing happens in my day job. It's very quiet and relaxing, as you can probably imagine. We are here for, I think, a really exciting conversation. I want to run you through a little bit of the format for how we're going to work here, and then we'll sort of dive right in. Before us, we have four distinguished folks representing people who have served with the in a civil rights capacity in the United States government for the past since the Johnson administration right through to the Obama administration. There are, of course, many things in this field happening today. We face constant debates about immigration, about voting rights, about police, pardons. I'm sure we'll get to a lot of it today. I don't want to take all of the time, though. I'd like to initially start just by turning it over to our very distinguished panel. I'll introduce them briefly. They'll introduce themselves more. Then we'll get into questions. We will have a roving microphone, so if you have something, please raise your hand. I hope to get to a lot of questions today so we can have a free-flowing sort of audience panel-led discussion. To the best of my ability, I'll try and stay out of it as much as possible. Starting from my far left, we have Stephen J. Pollack, who served as an Assistant Attorney General for Civil Rights under President Lyndon Johnson. Pollack is a Lawyers Committee board member and former co-chair, led the division in the wake of the assassination of the Reverend Dr. Martin Luther King Jr. During his tenure, Pollack led the implementation of programs to combat employment discrimination and ensure fair housing. Today, he's of counsel at the law firm of Goodwin Procter, LLP. Next to Stephen, we have Stan Pottinger, who led the Civil Rights Division from 1973 to 77 during both the Nixon and Ford administrations, and he was telling me he had a little bit of time under Carter as well. So lots of ideological continuity there, I'm sure. Excuse me. Later became an investment banker, novelist, and lawyer in private practice. In 2013, he was signatory to an amicus brief submitted to the Supreme Court in support of same-sex marriage. Today, he leads the Pottinger Firm, LLC. Skipping over the podium to my right, John Dunn served as a state senator in New York for 24 years prior to becoming the Assistant Attorney General from 1990 to 1993 during the George H.W. Bush administration. Currently, he is a senior counsel at the law firm of Whiteman, Osterman, and Hanna, LLP in New York State. And then to his right, someone who we have quoted at Bloomberg a fair amount during the past couple of years, Vanita Gupta, was appointed to lead the Civil Rights Division by President Obama in 2014, where she remained until January of this year. While at DOJ, she led the Civil Rights Division's response to a range of matters from hate crimes and policing to voting and criminal justice reform. Prior to joining the Justice Department, Gupta served as Deputy Legal Director and the Director of the Center for Justice at the ACLU. Today, she's President and CEO of the Leadership Conference on Civil and Human Rights. And Stephen, if I could turn it over to you for a couple of brief remarks, we'll go down the table and then we'll start with questions.
Morning, everyone. I served as first assistant and then assistant attorney general March 1965 to January 20, 1969. As my revered predecessors, Assistant Attorneys General Harold Ace Tyler, Burke Marshall, and John Doerr aren't here, I'm going to highlight their notable achievements as well as my own. The division's single most notable achievement during its first 12 years was the pivotal role it played in securing the right of black citizens in the South to register and vote free of discrimination. As the Supreme Court said in 1886, the right to vote, quote, is a fundamental political right because it is preservative of all rights. Elimination of barriers to blacks voting changed the political face of the nation from the smallest county and school district to the President and the Congress of the United States. Between December 1957, when Attorney General Brownell established the division, and January '69, when I departed, the division's small band of attorneys and paralegals accomplished virtual miracles in facilitating passage of the Civil Rights Acts of 1960, 1964, and 1968, and the Voting Rights Act of 1965, and commencing enforcement of newly recognized rights against discrimination in voting, public accommodations and facilities, education, employment, and housing. I'm focusing today on voting, the right preservative of all rights. Prior to enactment of the Civil Rights Act of 1964, the division's civil jurisdiction was limited to voting, and that's where it concentrated its activity. John Doerr sent division attorneys south on Friday evenings so they could work 9 full days before returning to D.C. their second Sunday evening. Their mission, to root out barriers to registration of blacks, and once suits were filed, to assemble massive records and identify witnesses needed to convince Southern District judges that requirements for registration and voting were being applied discriminatorily. Building on the efforts of civil rights organizations to help people register to vote, the division, by July 1965, had resolved or was still litigating 59 voting discrimination cases. Progress proved elusive. Opposition was entrenched and implacable across most areas of the South. Case-by-case litigation, the only vehicle available, proceeded at a snail's pace while blacks remained without the vote. When a victory was achieved and a discriminatory practice enjoined, the state or county substituted a new barrier, and the process had to begin all over. The division's efforts established an extensive, irrefutable record of discriminatory techniques and demonstrated which remedies were effective and which remedies were not. When Bloody Sunday brought discrimination to the nation's attention, the division applied this learning to the nation, to drafting the Voting Rights Act, and presented the factual record to Congress in support of the bill. Unlike today, the President and the leaders of both parties in the House and the Senate supported the bill. I was privileged to see this firsthand as the Johnson administration's representative negotiating the final terms of the legislation with Majority Leader Mike Mansfield and Majority Leader Everett Dirksen, representatives. Passage was nearly unanimous, except for the Southern Democrats. The rollout of the Voting Rights Act by the Civil Rights Division is another unsung major achievement. It was the federal government's first experience handling registration of voters. Preparation started early, 4 months before August 6, when President Johnson signed the bill. Implementation of its provisions had hundreds of moving parts. Here's a couple of examples. Attorney General Katzenbach sent a letter to the local official responsible for registration and voting in each of the 509 counties and parishes covered by the Act, explaining its provisions, most particularly the suspension of livery tests and other subjective devices as voting qualifications, and stating that all applicants meeting requirements of age, residence, citizenship, non-adjudication of insanity, and non-conviction of crime were to be registered. Any changes in existing practices and procedures for registration or voting were to be submitted to the Attorney General or the U.S. District Court in the District of Columbia for pre-clearance before being put into effect. Where local officials were unwilling to comply with the new federal law, the Attorney General would and could assign a federal examiner to do the job, a civil service employee. In rural Lowndes County, Alabama, no property owner would rent space to the federal government. So we arranged for a trailer to be moved onto U.S. Post Office ground. And the examiner was open for business on August 10, 4 days after the bill was signed. By October 1967, registration in the heart of the Southland, Alabama, Georgia, Mississippi, Louisiana, and South Carolina had increased by 76%. More than half of the age-eligible blacks in these Old South states were registered. In Mississippi, which had the lowest rate of pre-act registration, 7.2%, the rate increased almost six-fold, moving to 41% of the black voting age population. With federal observers present at key voting places, newly registered blacks voted freely and in great numbers across the South in the primary and general elections of '66, '67, and '68, the first elections under the Voting Rights Act. No civil rights statute has worked better or more smoothly. It is beyond disheartening to contrast this history with the voting wars of today. The prior unity of purpose has apparently collapsed. The Supreme Court eliminated the Voting Rights Act requirement for pre-clearances of changes in voting procedures and practices, so that challenges to new onerous voter ID and other rules changes must again proceed case by case. Bills that would restore pre-clearance for states and counties with records of race discrimination languish, while the President and Republican leadership of the Senate and the House credit unfounded claims of voter fraud and lend support to voter ID laws that disparately burden minorities and the poor. Requirements for birth certificates and voter ID cards obtainable at a financial cost are becoming the new tests and devices and poll taxes. The Attorney General reversed the federal government's position on whether the Texas voter ID law was passed with discriminatory intent, and whether Ohio's process for purging its voter rolls conforms to requirements of the Voter Registration Act of '93, known as the Motor Voter Law. The great civil rights acts of the '60s remain on the statute books. The nation needs a civil rights division and an attorney general committed to perform the federal government's responsibility to enforce them. Thank you.
Good morning, everyone. Stan Pottinger. I was Assistant Attorney General from early '73 till 1977. And let me just clarify one thing on the record, since the record matters, especially when we're making a record. I was not Assistant Attorney General under President Carter. I was a special assistant to Griffin Bell, President Carter's Attorney General, for a few months. But during that period, my good friend, distinguished friend, Drew Days, was Assistant Attorney General. I have 3 points. One, that the Civil Rights Division is an institution and should be. 2, that it is a bipartisan institution and should be. And 3, that if I may suggest, since we're in the press club, and the press has a major interest in this division as well as the history of it, I would ask the press to keep in mind that you should always watch what the Civil Rights Division does, not necessarily what its critics say. With regard to the history of the division, Steve has nicely set forth a kind of paradigm of what happens in this division. It is on the forefront of change, and change that is so key to the American experience that it's impossible to imagine the United States government without the Civil Rights Division. It has survived many different attacks, and it has prospered under those attacks. I recall that in 1970s, in fact, I think it was May Day 1970 when I came to work here in Washington, the bridges to the city were lined with troops, helmeted troops with M1 rifles at their sides. APCs roamed the city. Entire portions of it were blockaded off. No one was allowed to cross those lines in their cars. If they mistakenly did so, Chief Wilson had them arrested and processed at RFK Stadium, pretty much the way you would in a South American country that doesn't respect rights, banana boat sorts of places. This was Washington. Big hunks of the city were burned out. Parts of Cleveland were burned out. Parts of Los Angeles burned out. There was a M60 machine gun on the steps of the United States Capitol. You're welcome to look that up in the New York Times. Pictures of it, helmeted troop behind it. The Vietnam War had rent the country very badly. And yet, despite that, and despite the Southern strategy and the political forces that were in operation at that time, the tide of which was against civil rights, despite all that, the Civil Rights Division prospered or survived and then prospered, began to turn that situation around in the second administration and then into the Ford administration. Now, the reasons for that have to do with the quality of the staff of the Civil Rights Division. Not so much those of us on this stage, but the quality of the people who run the Civil Rights Division day in, day out makes that division what it is. I myself had 3 terrific assistants, one of whom is here, Jim Turner. The section chiefs were spectacular, the lawyers professional, and that did continue, and I believe still continues today. Keep that in mind. And in the press, if you are looking for an idea of what's going on in the division, make sure that you talk not only to the Assistant Attorney General and the press person, whoever that is, talk to section chiefs, talk to people who are lawyers in the division, and talk to the people who are on the outside. They will tell you what's really going on. I have the pleasure of seeing my good friends, Judge David Tatel and Jim Robertson here today. They kept me honest as I could be. And that relationship that you have with people who are on the outside is critical. It's critical. And if you really want to know what's going on, not only ask people on the inside what's going on, ask people on the outside who are dealing with the division. With regard to bipartisanship, it'll always be here. I Googled this morning briefly, and I saw that the Civil Rights Division has been led by Republican appointees more than Democrats over its history, and has been under Republican rule, so to speak, longer, more years than under Democrats. Now, you're entitled to say, yeah, but what did any of those Republicans do and what did the Democrats do? Fair question. But I would simply say very quickly that perhaps no one exceeded the accomplishments of the division as an Assistant Attorney General greater than John Doerr, who was himself a Republican from Wisconsin. I'm not here to talk about Republican politics or to defend any Republican politics, but simply to note that that bipartisan tradition is important and I think will continue. Finally, I said, watch what they do, not what other people say. I learned that lesson not so much from the administration, but on a trip to Mississippi when I was the head of the Civil Rights Office at HEW. And all of us who were sitting at a table like this, we're talking about winning the hearts and minds of whites, because after all, we white males, which happens to, I see, to compose most of this audience, we're the problem, not minorities, not women. I mean, if we talk about generically or generally speaking. So we were talking about how to change the hearts and minds of those people in power. And after it was over, and all three of Ruby Martin, all of us spoke, a gentleman who was a reverend of a Baptist church came up to me afterward and said, look, I appreciate what you're saying, but you're just all wrong. I don't care about your heart and your mind, and I don't care about changing the hearts and minds of those around us. I was surprised. He said, what I care about is how you behave. I care about how I'm treated. I care about how people in my community are treated. I care about how you legislate and how you enforce the law. I care about what you do, not what you think. And then he walked away in a friendly way. I've never forgotten that. He did add one other thing. He said, if you do right, and you do right by us, then hearts and minds will change after that. So keep that in mind. Watch what the Civil Rights Division does, because I think you'll find that it will stay its course. It will continue to perform its mission professionally and capably, and serve the country as well in the future as it has in the past.
Stan, thank you for those very encouraging words. Is this working? It is. First, I haven't heard anybody sing happy birthday. But anyway, happy birthday, 60th, for what is, I consider to be the heart of this great federal government and its administration. Listening to the two prior speakers, I recognize that the privilege I had was to stand on their shoulders for the enormous work that they did to not only see enactment, but the enforcement of such important legislation. And third, I really want to single out one comment that Bob Mueller, who at the time at the department, he was the head of the criminal division, when we were all packing up, going back to our homes after our boss had been defeated, which was a dark day, he said to me, you know, you had the toughest job in the department. And coming from Bob Mueller, and we've heard about him recently, haven't we? It was a great compliment to the work that, not particularly myself, but the tradition of the Civil Rights Division. I'd like to just take the few moments I've been allotted to talk more about the operations of the department. When I arrived in April of 1990, the Bush administration had been in operation for 15 months, and there had not been a filling of that position. But thank God for the career Deputy Assistant Attorney General Jim Turner, who was a career person there, and he acted as the Assistant Attorney General for those 15 months. He kept the division alive and well, and initiating all kinds of very significant civil rights measures. Bring this lawsuit against Virginia Military Institute for its gender exclusionary policies, although 1/3 of their budget was provided by the federal government, a clear violation of Title VII. He saw to it that the litigation against Los Angeles County, because as a violation of Section 2, since the County Board of Supervisors, all 5 members ran at large, thereby preventing any significant minority representation in the County Board of Supervisors. And it was Jim who really field generaled that litigation. We won the liability part of it, and then it remained to our new administration to find out just how to seek justice by dividing the county into 5 separate districts. He saw to it that we responded to the various recommendations from the IRCA Commission involving the employment-related discrimination problem, which had been a source of concern and kept many immigrants from having their rightful position in the community. So with that, that record of keeping the store open and doing what was expected of the Civil Rights Division, we then undertook to follow through on a series of measures that at times were difficult to carry through on, because I'll be quite frank with you, there was a certain amount of tension, not only within the Justice Department. There were a great many still there who had been in place since the Reagan administration, which admittedly did not take a very enthusiastic position with regard to the enforcement of some of the very important civil rights laws. But also there were a great many Reagan carryovers from who were still in the White House, watching what we were doing at every stage. Having come from a political background, and legislation where give and take and try to work out solutions to problems, I think that we were able to handle those tensions. But I would give you one example of one. Jim had seen to it that a Section 2 procedure against Texas with regard to the election of judges in the state of Texas. And they were elected by districts. They've been elected at large, preventing the election of minorities to the important judicial positions in Houston. I argued the case in the Fifth Circuit to sustain the trial judge's finding that there was a violation of Section 2 by reason of the at-large election. It was probably one of the most difficult sessions I had, 13 minutes before the Fifth Circuit. You can imagine their basic approach to civil rights matters. And the issue there was whether judges were included within the Section 2 provision that it covers the citizens' right to elect representatives of their choice. And many people felt that representatives just meant members of the legislative body. It was the position advanced by the division that it should include judges. Well, that wasn't a happy day when they made their decision, but having argued the case and having come up on the shorthand, I wanted to urge the Solicitor General, Ken Starr, to apply or support in a amicus role to support the position that the division had advanced. I first had to go by John Roberts, who was the Executive Deputy Solicitor General, and if any of you are familiar with his record as an advisor to former President Reagan, I received a rather cool reception. I often thought that debating with John Roberts is like wrestling with a bear. He's so powerful, so smart, so resourceful. I lost that argument. I figured, go see my friend Ken Starr. Well, he agreed that we should file an amicus brief on behalf of our position, and the Supreme Court granted it and decided that indeed judges were included. Let me just conclude with that. There's a tremendous unfinished agenda, particularly with the new administration. But I believe that there is ample evidence of the past that with a strong, hard-fighting, intelligent leadership in the Civil Rights Division, it can be an enormous force for good. And I'm so delighted that I'm here with the one person I think I have more admiration for than any other. Anita's done a great job, and I hope that in our exchange we can bring some more enlightenment and work toward the goal we all share.
Goodness, it's going to make me get teary, but I really appreciate that incredible statement. And I have to tell you, just being here and seeing and hearing the sweep of the history of the Civil Rights Division is really incredibly moving to me, because I could not agree more that despite all of the kind of winds of change and turmoil that this country endures and that we are presently enduring, there's no question that the Civil Rights Division is indeed an institution, and that it is one of the most deeply resilient institutions given the amount of kind of attacks and forward winds that it faces every day in the work that it does. I want to just start by thanking my good friend and colleague in the work, Kristen Clark, and the Lawyers Committee. As one of the previous speakers said, you should be talking and constantly reflecting with folks on the outside who do this work because they hold you accountable. The Lawyers Committee did that for the 2.5 years that I had the privilege to lead the Civil Rights Division. And I'm now really proud to call Kristen a tremendous peer in the work because the Lawyers Committee is doing just fantastic work on civil rights today. I am also just deeply honored to be here alongside legends in the Civil Rights Division. And I will just say serving the Justice Department was the honor of a lifetime. It was not anything I had ever imagined would be a part of my career. I arrived at the Justice Department in October of 2014, just weeks after Michael Brown had been shot and killed in the streets of Ferguson. There had been, obviously, as all of us know, a tremendous unrest. I arrived in the middle of ongoing unrest, not only in Ferguson, but around the country. And during my time at the Civil Rights Division, I don't think I could have possibly imagined. I knew I was walking into a situation with Ferguson, but I think policing in particular and police community issues and tension and issues around racial justice and public safety really was one of the dominant factors of my tenure at the Civil Rights Division. It was during that time that we issued a report, an investigation, both into the Ferguson Police Department, which really, I think, unveiled for many in this country the interconnectedness between what's been happening in our criminal justice systems and the levying of fines and fees on African American residents and low-income residents in particular, and the connection with policing and police practices, where we uncovered also tremendous racial bias in policing, and a lot of police officers that were very unhappy about having been made debt collectors rather than real guardians of public safety. During the time I was there was the unrest in Baltimore following Freddie Gray. Every week it seemed there was a new video that was going viral. Technology has changed so much of what and how the American community processes and understands what is happening in our criminal justice system, and oversaw the investigations in Baltimore, the consent decree, as well as the investigation into the Chicago Police Department. But also during the time that I was there, I would say civil rights enforcement was front and center for the country. As one of my prior predecessors mentioned, we were a year and a half into a post-Shelby County world where the Justice Department lost one of the most vital tools to protect the right to vote in the Shelby County decision. And there was such an intense, it wasn't just new to that time, but the intense politicization of voting rights has been one of the most deeply distressing, disappointing, sobering features of our civil rights world today. And you hear just kind of across administrations represented here how deeply important that work is, and yet today how deeply politicized that work has become. But in the course of my tenure, we filed appeals into cases where states like Texas and North Carolina, in the immediate aftermath of the Shelby County decision, had enacted some very restrictive voting laws that were really making voting much harder, and in fact yielded federal appellate court decisions from the Fourth and Fifth Circuits, saying in the Fourth Circuit, I'll just say, where it found that the North Carolina legislature had engaged in intentional race discrimination with such surgical precision, was the word that was used in the opinion, that prevented African Americans from enforcing their right to the franchise. This was all happening as we were at the Civil Rights Division. There was a lot of energy in ensuring voting rights and free access to the franchise. We also were doing a lot of work on LGBT rights, the evolution of the country. In so many ways, the history of the Civil Rights Division, I think, really is so reflective of the history of this nation's progress and sometimes retrenchment on civil rights. But while we were there, the Oberg, we litigated with the SG's office under the tremendous leadership of Solicitor General Don Verrelli, the Obergefell decision, and also then challenged North Carolina's HB2 law discriminating against transgender people, among other things. But the work was so vast, and it was deliberate and thoughtful, and at every turn there was intense discussion across the components at the Justice Department to figure out what the position of the United States would be. I was so honored to serve in that time, and I was very proud of what we accomplished. I have been known to have been an aggressive head of the Civil Rights Division, and I sometimes comment that people don't make that comment about other component heads who are expected to be aggressive in the enforcement of the laws that Congress enacts, and sometimes it's used as a derogatory word, and yet aggressive civil rights enforcement is, to me, one of the finest qualities if you're going to head up the Civil Rights Division, regardless of whether you've been appointed by a Republican or a Democratic president. To me, seems to be what you should do in order to fulfill the four corners of your job. I will just also, I want to say that, so much of what we did, sometimes the head of the division gets the credit for, but really, there is no question in my mind that it is the heart and soul of that division has always been the career men and women. When at my time, I know, Steve, you mentioned that there was a handful of lawyers. By my time, there was just under 700 career employees that were enforcing our nation's civil rights laws, and they do it with tremendous zeal and integrity and commitment. We were able to do the kind of work on criminal justice reform and policing and access to counsel and fines and fees and all of that and LGBT rights because of the amazing integrity of the men and women who make up that office. I will say, and I'm always an optimist, that's why I'm a civil rights lawyer, but I think it would be remiss of me to say that these times are deeply challenging, and I worry about the ability of the career men and women at the Justice Department to do their jobs effectively when there's too much politicization of their work. And, it is a challenge. It makes it difficult for them to be able to continue to do what should be purely kind of a law enforcement function in their jobs. But these issues are very challenging, and they always have been. This work has never been anything but upstream. And I take a long view of history, which is to say that our progress in this country has never been linear. It has taken fits and starts, but it is always, and none of it has been inevitable. And the institutions are not, they don't exist without people constantly pushing to ensure that the rule of law is maintained and that people are able to do the jobs that they've been given to do by Congress. And so this is deeply important work. The institution touches every area of American life, as you all know, and I think it's really incumbent on all of us to do what we can to protect the institution and to ensure that the career men and women who do this work are able to do it without interference and kind of with the integrity that I know they all want to do it in. So thank you.
Thank you very much. I want to lead off the questioning, and then we'll get there. And one of the things that I'm struck by is we go through the sweep of it, and there's so many things that fall under there. I kind of want to, in the moment that we're in right now, Stephen, you were saying voting rights underpins everything. That's the key. But Vanita, what do you think is the most important thing right now? Most important issue facing the division?
It's a really difficult question to prioritize one. I mean, I do think that voting rights undergird everything else, but I will say it's, people also have to exercise their right to vote in order for it to have that meaning. But I can't pick one issue. I think right now for the division, the ability to enforce the laws in the areas of voting rights, in the area of policing, which continues to be an issue where there's tremendous tension, even if the media is unable to cover it right now the way that it had been. Access to opportunity through all of the bread and butter work on disability rights, employment rights. These things have deep impact on people. Some of it is higher profile and under greater attack than others, but I think every area, this is what was so astonishing to me at the division, is every area of enforcement that the division engages in is deeply impacting on communities and people. And so, but I think right now, because of some steps on voting rights and the depoliticization and the Pence-Kobach Commission that one of my predecessors referred to, I think there is a real concern about really closing the doors on access to the franchise and the different steps that may be getting laid right now that we may see come to bear that are going to be very challenging and are going to have a distorting effect on kind of the history of the work that's represented at this table on these issues.
I'm going to start throwing the questions out. This is my microphone, so please don't, abuse the privilege here. But if you can identify yourself and speak clearly in there, because we have people watching on a live stream. Identify yourself, what outlet you're with, and then ask your question.
Hi, thanks, Derek, and thanks to you and Jamie for organizing it and for all you did with the club. I'm Bob Weiner. I'm a National Press Club member and op-ed writer, lead a group of op-ed writers, and Ben Lasky is our top assistant, so also a full club member. You guys are the national leaders in this field. You have been cutting across many administrations. You've said that you want to have the underneath people under the Civil Rights Assistant Attorney General work without interference. But really, in this administration, you expect that? So what I want to ask is, are you depressed about what's going on? And it's a serious question. And do you think that voting rights will be chopped? Do you think that college and housing affirmative action will be chopped? Will enforcement, law enforcement, revert to worse for minorities, worse impact on minorities? Will women's pay equality be lost? Will age discrimination come back? Those are serious questions that the current next to be Assistant Civil Rights Division leader will head up, and yet we know where Attorney General Sessions wants to take it and where Donald Trump seems to want to take it. So are you depressed that all of your work will be lost? And what can be done to fight back? What can be done to maintain those issues?
Let me jump in on that and try to be brief, because it's something I thought a great deal about. When you sign on to an administration, take a very sensitive and policy-making role, you have two responsibilities. One, as a member of a team, you've signed on as in support of the president, and you have to try to be part of that team. But if being part of that team offends your basic sense of justice, then it's time to say goodbye. On the other hand, you also have taken an oath of the office to uphold the laws of the United States. And that's the real challenge, to separate the responsibility as a part of a political team, which is perfectly legitimate, but on the other hand, to really try to achieve what you sense was the intention of the legislation, of the legislators who enacted those laws. I found that time and again, there was a tension there, coming from vested interests, coming from people such as John Roberts when he was at the Justice Department, wanting to cut back on or limit the application of a lot of the civil rights laws. Now, being part of the team when we were debating the Kennedy-Hawkins bill, which was a response to a number of Supreme Court decisions which collectively cut back on employee rights, while I was not in sympathy with the position that the White House was taking, I felt that I had to support them as the legislation was being drafted. That's a political decision, but it did not keep the division from forcefully emphasizing and carrying out the employment protection laws. So it's a difficult thing. But in answer to your question, I'm not encouraged, I'm discouraged. I just hope and pray, and I do pray, and I think that may be in the view of some as the only thing we got left, is to try to have the newly nominated head of the Civil Rights Division to recognize that he's not a political activist, that he hopefully does not share a number of the positions that Mr. Sessions has espoused publicly, and that he will draw the agenda of the division more closely to what we thought was intended when their enactment was made, and have been carried out, I think, fairly faithfully by the division.
I would just add something. The Civil Rights Division is a major force, but it is by no means the sole actor. So we've got a tripartite government. We have the courts, they're going to play a role. We have the legislation, it remains on the books. And we have non-government organizations like Benita's organization, like the Lawyers Committee, ACLU, Migrant Workers' Rights a panoply of organizations. They're not going to be idle, and they're going to be called on for law enforcement roles that private parties can play when the Civil Rights Division doesn't step up. But I'm hopeful that facts will still play a role in what the division presents up to the Attorney General, and that the nation will be looking on if enforcement fails.
You know, I'm at the leadership conference, and my views are fairly clear on where I think that things are. I think I'm deeply alarmed by the state of civil rights enforcement. I would say not only at the Civil Rights Division, but really across the federal government. As you know, every federal agency has an office for civil rights. And it has been very distressing. People have asked me whether I personally feel a certain way because I'm watching things that I have signed get undone, positions reversed, trials that we worked on for years where we are, like in the Texas ID case where at the Justice Department in new months of the administration reversed longstanding position around intentional race discrimination and the like. It is painful, but it isn't personal to me. It is, I think, a situation where especially after events like Charlottesville and the response of the administration, it is a time where I think the work on the outside is as critical as ever, and as Steve mentioned, the work of nonprofit organizations that litigate, that do advocacy, that are trying to hold and make sure that Congress exercises its oversight function in the appropriate way, which also is a challenge right now. That these are critical vehicles, and the courts have been very important, but we need to make sure that the judiciary remains independent. And so there's a lot at stake right now. I don't think that we should be minimizing the context in which we find ourselves. But I also, because I am a deeply optimistic person, and you look at the history of this country, we are going to get through this, but we're going to get through it because people, like many of us in this room and outside, are doing what we can to ensure that American values are maintained and that the rule of law is maintained. But it is certainly taking a lot of energy and work, and we will continue to engage in it. And my hope, as I said in closing before, is that the career men and women of the division are able to do their jobs without interference. But we have seen, concerns about that in real ways played out in recent administrations, and we need to be able to do and the Congress needs to be able to do what it can to ensure that they are allowed to do their jobs.
Well, I basically share Vanita's optimism. I say that basically. That doesn't mean that the questions that have been raised here about what will happen, we're always looking for what will happen, which requires speculation. Doesn't mean that those questions are not really solid questions and cause for concern. But when I attended the opening of the Lyndon Johnson Library in Texas a month before he died, Hubert Humphrey was there, and he turned to the audience and he said, he was known as Mr. Civil Rights. He said, we in the civil rights community are never so happy as when we're unhappy. There is something about this aspect of life that makes us extremely nervous and ready to not throw in the towel, but worry deeply, or as you said, get depressed. Thank you for asking about my state of mind. But I don't believe that it has to be that way, even in an administration that sets a tone contrary to what it is that we would set the tone on in this room. And I say that in part because I was there. Busing probably was as deeply disputed and controversial as any policy that we'll find for some years. The Nixon administration was known to be against busing, or I should say the White House was, and yet the president, March 25th, 1970, says we're going to do it now, and that year was the largest dismantling of dual school systems in the country's history, more literal busing that year than ever before. So you can't simply do not take the words, do not allow yourselves as members of the press, if I may say so, and I don't mean this in any patronizing way, but do not be so literal with everything you hear. Things that you hear are political statements. Many of them are metaphors as opposed to literal policy statements. Watch what the Civil Rights Division does. The biggest defense it has, at least I had, was the law. You know, when senators and congressmen would make me come up to the Hill and say, how can you be in favor of busing and hauling? How can that be? And you cited what the law was, you cited what the Supreme Court had said in Green against New Kent County. When you cited what the policy was on a basic statement, most of that disappeared. And frequently you would also find people who are making a statement for their own constituents on the one hand, but privately are saying, we understand that we're not asking you to abuse the law. Now that does not address the question of new initiatives. New initiatives can be held back because they're new. You don't have a law behind you. But if you have a law behind you and you have an assistant attorney general who respects the law, do not get too overly depressed.
I think we had a question back.
Thanks, Irv Chapman with Bloomberg Radio. I'd like to ask the two who served in Republican administrations to weigh in on the issue of voter suppression, which is working its way up to the Supreme Court, how you think it might fare when it gets there. And also the issue of gerrymandering, which minority Republicans have filed an amicus, how that fits into what we can look ahead in the days ahead.
I've thought long and hard about the prospects of the Wisconsin litigation with regard to districting. Having been in the legislature, I'm used to figuring out counting votes. Have you got the votes? I have difficulty trying to identify 5 of the justices who would come down on what I believe should be the decision, namely to consider political gerrymandering as a basis for the courts being involved. And I know it may be a thin reed, but I think that it is a possibility. Of course, I always wonder where Justice Kennedy is going to be, but there are 4 pretty sure ones on one side, but I just don't know the 5th. But the whole issue of voter suppression and districting came clearly in mind to me within the first couple of months after making Section 5 decisions quite often. And I went to Attorney General Thornburg, who I'd known for many years, and I said to him, Dick, I'm making these decisions with pretty significant political significance. Do you want me to run them by you before I issue them? Without missing a beat, he said, absolutely not. I want no part of it. Just promise me, do what you think is right. And I think that, well, it was a great compliment, but it was pretty scary to have that responsibility. I think that really typified what was expected of the person who had the very important role of running the Civil Rights Division. Now, I guess it takes a big ego to say, well, I think this is right, and therefore that's what we're going to do. But you came to the decision on what was right after working with, respecting, analyzing the work of the career members of the Civil Rights Division, and things worked out pretty well that way. But just try to do what you think is right. That's pretty nice litmus.
I have no problem saying that the number one issue in the division is voting. I think that Steve Pollack's opening statements set the stage for that. And I think because it is the underpinning of everything else, that's number one. Doesn't mean that number 2 through 20 aren't very close and important. Number 2, with regard to gerrymandering, it's a major, major issue that goes well beyond civil rights. It is so basic to the Constitution and the rupturing, in my view, of the political process that it will have to be dealt with across the board, politically, in the Congress, as well as in state houses. What we have now, at a time when everyone says Republicans and Democrats can't even talk to each other, is an unbelievable deal of the devil between the two of them, and that is to make sure that everybody in Congress stays elected. So that the gerrymandering that has happened, along with the free flow of money that goes with it, has, in my view, deeply perverted the process. We now have, even in times of enormous political upheaval, some very tiny number of people who are unelected in the United States Congress. I mean, that if you can't get unelected at times like this, when we have major policy differences and provocations in front of us, when can you find a turnover of leadership in the Congress? And that, in my view, is completely or almost completely a function both of money and gerrymandering.
I have one thing I want to do real quick. I know that a lot of you have questions and you would like to try and chat with our panel individually, so I'm going to try and have some time with that. Oh, thank you. I'm going to try and have some time with that, but we do have something that we have to give out, and I've got to say, we do this. We've given this out to statesmen, to presidents, to kings, to rulers, and I promise you that it fits within the ethical donation limit, and that is the National Press Club mug. It's very fun. It's two-toned. It's got some gold trim on it. And I'd like you to have this as a small, emphasis small, but a token of our appreciation and emphasis on appreciation for your being here. No. If you have a couple more of those, you can buy some more at the shop at the front desk. But we do want to say thank you to our panel for coming. And the last thing I want to ask from the podium, and then I'll let you all have your individual questions with the panel afterward, is this. There is a new nominee. There was a hearing yesterday on Eric Dryban. I wanted to get your sense of the new nominee and where you think the department is going to go under that leadership.
Steve?
I've never met the nominee. I've never seen his resume. I read the article in the morning paper and the Post that spoke about the hearing. I received yesterday from Richard Seymour, who handled equal employment responsibilities for the Lawyers Committee for many years and has been a plaintiff's civil rights lawyer. I received from him a copy of the statement of the Leadership Conference vigorously opposing Mr. Dryban, and I received, much to my surprise, a 21-page indexed letter from Richard Seymour strongly endorsing Mr. Seymour because I had time to read the beginning and the conclusion. But beyond those materials, which I haven't been able to review, I have no views respecting Dryban because I don't know him and I don't know what he's saying or what the forecasts are. I intend to inform myself.
I don't know Mr. Dryban either. I think if you want to know about what people really think, as I said before, talk not so much to people inside an administration, but talk to the Leadership Conference off the record, talk to the Lawyers Committee off the record, and the NAA. My impression is, from talking with some of my friends there now, is that they are, as a matter of record, critical, worried, and in many cases opposed. I also believe that a number of them said, because based on his record at EEOC, they are not going to go full bore to the wall against him, that they don't want to take the level of opposition that they might take. I think you should check into those policy decisions on the part of a number of people in the Senate, as well as their staffs, as well as the outside groups, and you'll get a pretty accurate picture of what you think is going to happen. Finally, if he's confirmed, be patient. Watch what he does.
Thanks, Dan. John?
I was shocked this morning to hear that the confirmation process was so brief and non-probing. How can you consider a candidate who would have such power as an individual with regard to issues which are of daily concern and are of priority to virtually every community, not to be pushed to find out exactly where that man is coming from. I may be looking at it from the good old days under Dick Thornburgh, but the idea of, is this individual such that his judgment is going to be to do the right thing rather than to follow the political agenda which the current Attorney General has followed almost to the letter. It is shocking to think that the members of the Senate who have that right of confirmation have not pressed the candidate to head the division with regard to his position on these critical issues. Is he going to just be part of the political team, or is he going to do what he thinks is right? I think it was a terrible default on the part of the members of the judiciary, having gone through that process and having been interviewed not only by the full panel but individual members of that panel, to think that they are considering confirming an individual without a ghost of an idea other than some pretty negative stuff that's already been presented. So don't mark me in the uncertain column. I think that he ought to be called back for another examination.
All right, Jamie?
I'm Jamie Horwitz. I help guide the committee here that puts on these events. But as Stan had mentioned on the Lawyers Committee, and one of our past speakers for a Newsmaker is Kristen Clark, who is the director of the committee. And I was just wondering if you would weigh in on that. And then, but after that, if you'd indulge me with one other question. It seems like we shouldn't end this without asking all of you about DACA as well. So if I could pass the mic out there.
Sure. Kristen Clark, President and Executive Director of the Lawyers Committee for Civil Rights Under Law, and it's such a pleasure and honor to be here on the 60th anniversary of the Civil Rights Act of 1957, which, as we know, gave birth to the Civil Rights Division, such an important institution in our country. We are deeply concerned about the pace of the Eric Dryband hearing conducted by the Senate Judiciary Committee yesterday. That hearing did not provide the public a fair and full opportunity to understand Mr. Dryband's experience and commitment to enforcing the full range of federal civil rights laws that are handled by the division. And we can't ignore the fact that this nomination arises at a truly unique moment in our country's history, a moment in which we have an attorney general who has exhibited, sadly, grave hostility when it comes to civil rights, where we've seen the clock turned back on voting rights and criminal justice issues and policing reform. So unless Dryband is prepared to disavow some of the troubling actions that have been undertaken to date, unless Mr. Dryband is prepared to restore credibility and integrity to the division, I am deeply concerned about him being confirmed for this most important role. So thank you for the opportunity to weigh in.
And then, as Jamie so pointed out, we do have a I think major decision that the Trump administration put forward, sort of decision to get rid of the DACA program, maybe in 6 months. And I don't mean to be flippant about that. It's just there's a fair amount of uncertainty into what the actual decision was. And it seems like there's a room that's being left open intentionally for Congress to do insert thing here. It's vague because it is vague. And so I sort of wanted to close then by getting your take on that decision, where that goes from here, and what ought to be done.
Ending DACA is a cruel change of heart by the United States government. There are 800,000 young people who wanted to participate so they might continue to be contributing members of society. I think that the president has just bought some time by deferring to the Congress, which for 16 years has been unable to enact any significant immigration reform legislation. I feel sorry for those youngsters, and I hope that there will be a change of heart rather than a change of policy.
Well, I'll agree with what John just said. We're a nation of immigrants. I'm one, second generation. I guess quite a few people in this audience are immigrants. It's impossible to talk about the existence or future of this country without talking about immigration. I mean immigration as a positive good for this country. I think that DACA, whatever is going on now in its political machinations, in the end, those students, I should say those kids who were born here or brought here and have become citizens in every respect you can imagine except for certification, that they will not be deported. You know, it's really difficult for me to understand how, you said, John, 16 years, it's really been longer than that this country, a nation of immigrants, can't have a sensible immigration policy where we open the doors and have a legal, prompt process to let people come in here as we have, and that we try to keep out an illegal process those people who are undesirable by everybody's terms, not for some esoteric purpose, not for partisan purposes, but for criminal purposes or the like. Why we can't have that kind of a policy is a disgrace to this country and a little bit of a mystery.
I would just say that I'm very much opposed to what the president did. He's done it. Counting on him to take a more favorable view is not the course that one could have any confidence in. So it's time for the Congress to act.
Yeah, good.
All right, we'll leave it there. Thank you so much for coming to the National Press Club. We hope to see you again sometime soon.